You're making me write everything down in the rain.
Sorry.
I kind of read it.
We have a court order from a judge.
The Tulsa DHS.
You don't care, but that's how it works.
Do you know what their names are? Just
Yeah, Kirstie, Kirstie. Hilton, Hilton. And then Lyndra, Lyndra. Bronford, Broad.
These people she is listing off are guilty of 18 U.S.C. 241 and 242. And according with Prince v. Massachusetts 321 U.S. 158, state encroachment, that it is cardinal with the Supreme Court that the custody, care, and nurture of the child reside first in the parents whose primary function and freedom include preparation for obligations the state can neither supply nor hinder. And it is in recognition of this in Pierce v. Society of Sister Supra that these decisions have respected the private realm of family life, which the state cannot enter. The Ninth Amendment provides that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people, meaning the Constitution cannot be used against itself when it comes to your rights. And the 10th Amendment, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Griswold v. Connecticut 381 U.S. 479. The Fourth and Fifth Amendments were described in Boyd v. United States as protection against all government invasion of the sanctity of a man's home and the privacies of life. We recently refer in Mapp v. Ohio to the Fourth Amendment as creating a right to privacy no less important than any other right carefully and particularly reserved to the people. The right to be let alone. Liberty and security reaching farther than the concrete form of the case then before the court. Advantageous circumstance apply to all invasions on part of the government and its employees of the sanctity of a man's home and the privacies of life. It is not the breaking of his doors or the rummaging of his drawers that constitutes the essence of the offense, but the invasion of his indivisible right of personal security, personal liberty, private property, where that right has never been forfeited by his conviction on some public offense. It is the invasion of the sacred right which underlies the Constitution, the essence of Lord Camden judgment. Breaking into a house and opening boxes and drawers are circumstances of aggravation, but any forcible and compulsory extortion of a man's own testimony or of his private papers or property be used as evidence to convict him of some crime or to forfeit his goods is within the condemnation of judgment. In this regard, the Fourth and Fifth Amendments run almost into each other. So it really doesn't matter that you have a warrant, sir. Today, you done got screwed today. Why did you get screwed today? Because I'm not going to let you get away with these atrocities. Nope. Sorry. Your warrant violated the Constitution. And because of that, because it violated the sanctity of the privacy of a man and woman's home, and states are prohibited from doing that, and you just violated Fourth and Fifth Amendment rights because that warrant was acquired without zero justification, zero evidence.
So she's doesn't like the court order.
Okay, Norton versus Shelby County, 118 U.S. 425. An unconstitutional act is not a law. It confers no rights and imposes no duties. It affords no protection, creates no office. It is in legal contemplation, is inoperative as though it had never been passed. The Due Process Clause does not permit a state to infringe on the fundamental right of parents to make child-rearing decisions simply because a state judge believes a better decision could be made. Troxel versus Granville, 530 U.S. 57, 2000. Schuer v. Rhodes. By law, if a judge is a state officer and the judge then acts not as a judge but as a private individual and his private person, when he be doing orders that seem to be incongruous. Okay, when a judge acts as a trespasser of the law, when a judge does not follow the law, the judge loses subject matter jurisdiction, and the judge's orders are not voidable, but void and of no legal force or effect. The U.S. Supreme Court has stated that when a state officer acts under a state law in a manner violative of the federal Constitution, he comes into conflict with the superior authority of that Constitution, and he is in that case stripped of his official or representative character and is subjected in his person to the consequences of his individual conduct. The state has no power to import to him any immunity.
Nah, I think that's it. If there is, I'll call you, but I don't think there's anything. So. Alright, thank you.
Because we are here on official law enforcement business, to serve a court order, she willfully resisted, and so she is going to drop her.
No. An arrest cannot be made without probable cause, which is a legal standard requiring sufficient evidence to lead a reasonable cautious police officer to believe a crime has been committed by the suspect. Simply resisting when the officer acted on her first, when they had no right to exceed their force, is not probable cause for a warrant for arrest for a crime that has not been committed, okay? So, while probable cause doesn't require definitive proof, it demands some form of evidence, whether direct or circumstantial, to justify the arrest. You didn't have no fucking evidence, and you said you didn't need evidence, but you did. Okay? You know? You did. Okay? You did not have reasonable grounds or facts. Actually, you've been unreasonable. Okay? This woman is guilty of nothing more than trying to defend her human offspring and children from government-sanctioned child traffickers, okay? That's what you people are. You don't understand anything. You think you're helping people, or even worse, God forbid, they get into your hands and get trafficked into a prostitution ring, which has happened, which I will blow the lid on, because fuck you. Either way, a court order based on no evidence and lack of due process is a void order, so you just effectuated a void warrant, so you can just be sanctioned for false arrest and false imprisonment now, which also leads to kidnapping. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation that would abrogate them. Rulemaking, as in this judge's court order. Okay? Miranda v. Arizona. I'm gonna go ahead and let y'all watch the rest of this clip.
Just leave them out for now. Yeah. Full cage with no window bars. Let's have a full cage with no window bar.
Somebody else to he says he's got a glass partition over on his spreadsheet's plugged in and trying to kick it.
Please don't talk about the court order.
Well, that's
I want to know about the evidence. Please. Tell me about the evidence.
That's not how this works.
But it's, you're violating rights. You are violating the rights of me and my people. Don't tell me you're not. What is it? You are violating our rights.
You want to set up
I am not a
so you can
criminal.
breathe better.
I just want to know what's going on. I'm not a criminal. I just want to know.
Okay, listen. I need to loosen the handcuffs on you. Okay? I need you to sit up. I need you to calm down. Okay?
What is going on?
We have a court order. We have a court order to pick your children up and give them over to DHS.
Why? There is no evidence of anything.
Why you have to talk to the judge about
Okay,
that?
what are you doing?
Yes, Joshua Victory. Yes, we have a court order. Here's a court order for you from a real judge. We have recognized on numerous occasions that the relationship between parent and child is constitutionally protected. We have little doubt that the due process clause would be offended if a state were to attempt to force the breakup of a natural family over objections of the parents and their children without some showing of unfitness and for the sole reason to do so was thought to be in the child's best interest. Be Quillon versus Walcott, 434 U.S. 246. Continuing, the statist notion that governmental powers to supersede parental authority in all cases because some parents abuse and neglect children is repugnant to American tradition. Simply because a decision of a parent is not agreeable to a child or because it involves risk does not automatically transfer the power to make that decision from the parents to some agency or officer of the state, such as what you're doing right now, good sir. You're not a good sir. You are fucking fired. Parham versus JR, 442 U.S. 584. Take that to the toilet and read it while you wipe. Because Parham versus JR, 442 U.S. 584, our jurisprudence historically has been reflected in modern Western civilization concepts of the family as a unit with broad parental authority over minor children. Our cases have consistently followed a course that our constitutional system long ago rejected any notion that a child is a mere creature of the state, but on the contrary asserted that parents generally have the right, coupled with a high duty, to recognize and prepare their children for additional obligation. Pierce versus Society Sisters, Wisconsin versus Yoder, Prince versus Massachusetts, Troxel versus Granville, Mayer versus Nebraska. All these cases, and this particular instance is based off from, quote, medical negligence. Well, it is the parents' decision what to do medically with their child, not the state. You can kiss our ass. Surely this includes a high duty to recognize symptoms of illness and to seek and follow medical advice. Because the law's concept of the family rests on a presumption that parents possess what a child lacks in maturity, experience, and capacity for judgment required for making life difficult decisions. More importantly, historically, been recognized that natural bonds of affection lead parents to act in the best interest for their children, which is not for the fucking state to decide, because the state ain't got nothing to fucking do with this, right? Because that's a violation of your fucking family privacy for them to send police into your private fucking domicile with a warrant based on some fucking bullshit, void order bullshit. Yeah, no, you violate the Constitution, your order's void, okay? And you taking them children becomes kidnapping, asshole.
The law. You're kidnapping. Yes, you are kidnapping my children. And you're kidnapping me if you take me. This is an unlawful arrest. I have broken no law. I've broken no law. I was trying to protect my children, that's all. There is no reason to kidnap my children. Please tell me what is going on.
Do it.
Why are you...
Yeah, Nine's
No,
en route,
please
but he's
don't.
gonna be a minute.
It's an unlawful arrest. Please don't. I was trying to protect my...
Look, so initially you just barged your way in and didn't have the warrant to present and did not present it after the guy told you that you weren't supposed to be in his house, and then you present the warrant later. That's not proper presentment of a warrant. On top of that, that warrant was not for her arrest, dumbass. You're an idiot. That warrant was not for her arrest. That warrant was erroneously issued for her children based upon fucking medical kidnapping information from some sort of doctor or some sort of fucking bullshit. Idiot motherfucker tattling on people for something that ain't their business that gets conflated and inflated into all of a sudden now you're kidnapping children. Okay. Well, I got a little something for you. Unconstitutional arrest is a seizure of a person by law enforcement without legal justification, such as a valid warrant or probable cause. It violates the protections against unreasonable seizures outlined in the Fourth Amendment of the United States Constitution. Such an arrest may occur if police lack probable cause to believe a crime was committed, make a mistake in identifying a person to be arrested, or conduct an arrest that is otherwise unreasonable under the circumstances, such as putting your fucking back in her, or knee in her fucking back where she can't breathe, and then grabbing her fucking behind with your hand. Right, so there's no evidence to suppress because there was no fucking evidence. So yeah. So what the Fourth Amendment requires for an arrest is the basis for your rights regarding arrest to be constitutional must be considered a reasonable seizure, generally meaning there must be probable cause to believe that a crime has been committed or is being committed. It is not a crime, right, to resist an unlawful arrest. That's not a fucking crime. They might want you to think it's a fucking crime. That's not a crime. When a police officer has illegally exceeded his fucking force and violated provisions of the Constitution, he has forfeited his oath and he's no longer a police officer. So after this point, it's all false arrest, false imprisonment. Warrant for arrests that are not in an officer's presence or under exigent circumstances. A warrant issued by a judge or magistrate is typically required. But the thing of it is even if the judge issued that order and it's unconstitutional, none of that shit matters because you already exceeded your authority when you fucking grabbed her ass. You stupid morons. Think, McFly. Think. Wake up. Okay? An arrest warrant must be supported by probable cause. You got probable cause, boss? No, you the fuck you do not. Okay? And she wasn't the person for which the warrant was issued. So kiss my ass and kiss her ass. Seriously. Stop child trafficking. Stop child trafficking. Stop.
Children were kidnapped.
All right, here. If you will let me talk, do not interrupt me. Let me talk.
You're not telling me what's going on.
I'm about to tell you exactly everything. Here's how it works. Whether you agree with it or disagree with it is up to you, but here's how it works. There is an order from a judge to DHS for your children to go into their custody. Period.
No, not.
Motherfucking overruled! Santosky versus Kramer, 455 U.S. 745. You're pissing me off. Before a state may sever completely and irrevocably the rights of parents and their natural child, due process requires that a state support its allegations by at least clear and convincing evidence. Clear and convincing evidence standard adequately conveys to the fact finder the level of objective certainty about his factual conclusions necessary to satisfy due process. Determination of precise burden equal to or greater than that standard is a matter of state law, properly left to state legislature and state courts. However, you gotta have some evidence, boss, and you didn't have none. And you just tried to attempt to tell her, period, she ain't ever getting her kids back and they're going into the hands of DHS. Think, McFly, think. Wake up. Hey, can I wake you up real quick?
HHS. The pipeline, man. We fed a pipeline of tender-age children into sex trafficking and slave labor.
No, I'm talking. You want me to explain it?
Here, let me explain it for you, dickbag. Statement by Robert F. Kennedy Jr., Secretary, U.S. Department of Health and Human Services on President Fiscal Year 2026 budget. We have also ended HHS as the principal vector for child trafficking. The budget refocuses the unaccompanied alien children. That don't fucking matter. But look. HHS became a collaborator in child trafficking for sex and slavery during the Biden administration operating UAC program. So why the fuck should we listen to what just came out of your mouth? You just agreeing to be complicit with child trafficking. Dumbass! Think, McFly!
Do you want me to explain it?
Yeah, you said period.
Then let me finish. Part 2. You didn't give the children to DHS willingly. I'm talking.
Go ahead.
The judge issued a new order to us as Tulsa County Sheriff's deputies to writ of assistance and take the children
That judge issued that order without a fucking hearing, without any of the fucking parties present, so everything you just did is conspiracy against rights, deprivation of rights under color of law, including kidnapping, which means you get the death sentence, buddy. I hope you're ready for the fucking electric chair. You wanna get fried, motherfucker? Or are you just stupid? You a special kind of stupid, huh? That's what it is. You a special kind of motherfucking dumb, ain't ya?
By any reasonable force necessary. And give.
Can I get breathe? I can't breathe!
Yes, you can. I know.
You son of a bitch!
And give them to DHS.
This is just because
Okay.
because I did not talk. What law have I broken by not talking to them? I do not have to
Okay,
talk to
you don't
them.
have to talk to them, but
Yeah, I didn't have to.
here, no, I'm still talking. When a judge issues an order to us, as sheriff's deputies, we are lawfully bound to execute his order.
Oh boy, you just really had to make this real fucking easy for me, didn't you, pal? 5 USC 333 oath of office. An individual except the president elected or appointed office in honor of profit in the civil service or uniformed services shall take the following oath. I, A, or A and B, do solemnly swear or affirm that I'll support and defend the Constitution of the United States against all enemies. Constitution of the United States against all enemies, foreign and domestic, and that I will bear true faith and allegiance to the same, and I take this obligation freely without any mental reservation or purpose of evasion, that I will well and faithfully discharge the duties of office on which you are about to be entering. So help you God. This federal law right here, see, because you obligated to the Constitution. 5 USC 3333, employee affidavit, loyalty and striking against the government. 7311 of this title. You got your affidavit? You got that affidavit saying you ain't gonna strike against my motherfucking constitutional rights. You fucking pig. And I ain't like this, y'all. But this time y'all done pissed me off. 5 USC 7311, loyalty and striking. An individual may not accept or hold a position in the government of the United States or the government of the District of Columbia if he advocates the overthrow of our constitutional form of government as a member of an organization that he knows advocates the overthrow of our constitutional form of government, or participates in a strike or asserts the right to strike against the government of the United States, the government of the District of Columbia, or as a member of the organization employees of the government of the United States or individuals employed by the government of the District of Columbia knows he has asserting the right to strike against the government of the United States or the government of the District of Columbia, which is our constitutional form of government. 5 U.S.C. 7311, Section 1. Because you just let an inferior state court judge's order violate the Constitution, okay? Without going and prosecuting that judge for not upholding his fucking oath of office. You pile of shit. That's a felony. 18 U.S.C. 1918, disloyalty and asserting the right to strike against the government. Whoever violates the provision of Section 7311 of Title V, that an individual may not accept or hold a position in the government of the United States or the government of the District of Columbia if he advocates the overthrow of our constitutional form of government, is a member of an organization that he knows advocates the overthrow of our constitutional form of government, participates in a strike or asserts the right to strike against the constitutional form of government of the United States or the Constitution of the United States or government of the District of Columbia, or is a member of an organization of employees, blah, 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 you know how it goes, shall be fined under this title or in prison not more than 1 year and a day or both. And you can no longer hold a position in any state or federal government of any state or the United States, you fucking pigs. You're fired.
No.
Okay?
No.
So, no, that's not a no. That's how it works.
No, you're lawfully bound to kidnap.
I'm gonna tell you right now, false arrest, also called wrongful arrest, is the unlawful restraint or detention of a person without legal justification, such as a valid warrant or probable cause. Valid. It is considered a violation of a person's civil rights under the Fourth Amendment, which protects against unreasonable seizures. Defendant intentionally confined by the plaintiff by arresting or restraining them. The plaintiff was aware of the confinement. The plaintiff did not consent to the confinement. The confinement was not supported by legal authorities such as probable cause or a valid warrant. False imprisonment is the unlawful and intentional restraint of a person's freedom of movement without their consent or legal justification. This can be accomplished through physical barriers. You even said yourself that she didn't consent to you, to the agency's bullshit. So it can both be a criminal offense and intentional civil wrong. It is correct that a warrant issued by an executive branch entity would be invalid as it would violate the separation of powers doctrine. Okay, them going there, getting the warrant, fucking not having a valid affidavit of probable cause attached to the fucking warrant, confining the children, smushing their mother in front of them. You fucking pigs! I'm coming for you.
Now, the order from the judge, we don't have a dog in the fight about what happens between it.
No, a police officer may not use excessive force, threats, duress, or coercion to violate your civil rights even while executing a warrant, acting with a warrant from an executive branch agency or even one of these, which is what these motherfucking judges are, because they under a cooperative arrangement to get some sort of fucking financial incentives for doing this shit. Does not grant immunity from liability for constitutional violation. Officers still bound by federal and state law, and acts that go beyond the scope of their legal authority can be prosecuted, such as not going after that judge for that bullshit that they issued. No, it doesn't work like that. You don't get to just, oh, that's the judge's problem. I'm sorry, under color of law. You were acting under fucking color of law. Because you were executing a warrant. This is the legal basis for holding out officers accountable when they overstep their power, such as 42 U.S.C. 1983 or 18 U.S.C. 242. Okay? Excessive force, coercion beyond what is reasonably necessary to execute the warrant is illegal, which is a fucking felony more than likely. You smell something burning? Smell something burning, bro?
We have a direct order from a judge. We, as lawfully sworn peace officers of Tulsa County, will follow the judge's order.
Alright, Mr. Peace Officer, 42 U.S.C. 1983, civil action for deprivation of rights, Troxel versus Granville, 530 U.S. 57. There is a fundamental right under the 14th Amendment for a parent to oversee the care, custody, and control of a child. Troxel versus Granville, 530 U.S. 57 again. Due process clause prevents the government from intruding on the fundamental rights and liberty interests, one of which is the liberty interest that parents have in controlling the care and custody of their children. The state may not give rights to any third parties, such as this police officer here, to challenge any decision by a parent regarding visitation, such as that parent's own fucking custody determinations, and including that fucking judge, with the parent's child in state courts. Giving the state court judge a discretion to determine the best interest of the child in each situation violates due process, especially when there's no allegation that the parent is unfit. It is reasonable to presume that the parents will act in the best interest of their children, so the state should not interfere and take that role away from them. Overruled! Also, I'm not a fucking judge, so no, I'm not impersonating a public official. Public officials, are you listening? Hello? Think McFly. Got a bar card? Color of state law refers to an action taken by a government official that appears to be authorized by the state or local government, even if that action is actually illegal or exceeds the officer's or official's lawful authority. It describes a wrongful act performed under the guise of government power, which is prohibited under the federal statutes like 18 U.S.C. 242. Okay? And when you're kidnapping in regards to 18 U.S.C. 242, that's a death sentence, buddy. You smell something cooking? You smell some bacon cooking, boys? 'Cause I do. I do. For example, a police officer who uses excessive force while making an arrest is acting under color of law, even though excessive force is illegal. The appearance of state law is not a legal doctrine itself, but a concept at the core of color of law doctrine. North Breeze, Shelby County, 118 U.S. 425. An unconstitutional act is not a law. It confers no rights, it imposes no duties, and affords no protection, it creates no office, and is a contemplation as inoperative as though it had never been passed. And obviously Santosky 455, 745, which I've mentioned before. Okay, before a state may sever completely parental rights, they have to have clear and convincing evidence. Got any fucking evidence that she's already demanded? That you failed to fucking provide? That the judge failed to provide? Just wait until I get into the documents, motherfuckers. I'm gonna eat you people alive for breakfast when it comes to this legal shit. You can kiss my ass. You can kiss this family's ass. You should not have violated this family's civil rights, you ignorant government piece of shit corporation. Now sit the fuck down! I'll be back for you!
Welcome to Ultimate Obsidian.